So good afternoon, everyone. It's my pleasure to be here with you. Just to get an idea of who knows what in the room, who here has a legal background? Nobody. Okay, so I can basically say what I want, and you have to believe me. Great. So I hope then lunch was good, and I hope that this won't make you regret having eaten before coming to the lecture. The fluorescent yellow is a way to keep you awake after lunch. I'm hoping it'll work. So before I get started my presentation, simply to mention, as I just put up on the screen, that my slides are available on my website, vermeys.com. So please don't hesitate to go there, but I understand that they will also be put up on the SERENE-RISC website at a certain point. So if you want to wait and get it from that source, feel free to do so. So my presentation, as you can see, is titled From Ottawa to Budapest, and you might be wondering why is he talking to us about Budapest in this conference? Well, as we'll see in a few minutes, there is an international convention on cybercrime, I should say an European convention on cybercrime, but that was actually opened up to the rest of the world. And that convention was actually signed in Budapest. So it's the Budapest Convention or the Cybercrime Convention, depending on who you speak to. But it's the same document, and hence Budapest in my title. So as we saw with our two panelists this morning, obviously the criminal code is the law that will guide us, if you will, in our search as to how we can attack cyber criminals. Only problem is, if you actually look through that law, if you actually read through the code and its many dispositions, you'll realize very quickly that there's actually no mention of cybercrime, and therefore no mention, also no definition. And this comes back to the question that this gentleman asked this morning, saying, well, what's your definition of what a cybercrime is? Because it's very difficult to have statistics on cybercrimes if you don't know what they are. We have a general idea of what we consider cybercrimes, but as we'll see in a moment, those ideas often are not relevant to what the law dictates is a cybercrime. The convention, on the other hand, again, the Budapest Convention or the Convention on Cybercrime, obviously uses the word cybercrime. It's right there in the title. It's actually used 8 times in the preamble, and it's also mentioned in section 46 of the law, or of the convention rather. But again, mentioned a couple of times, but not defined. So we do not, in Canadian legislation or in international treaties that are actually applied to Canada, have a definition of what cybercrime is. That being said, the convention does, in its preamble again, mention what is the focus of the law, and what they say is that basically we're trying to protect the confidentiality, integrity, and availability of computer data, of computer systems. Therefore, we're working on information security mostly. I say mostly because there are actually a series of cyber crimes in there, and some that have absolutely nothing to do with security, and I'll get back to that in a moment. So a little bit of background on this convention, since I'm going to get back to it or come back to it a few times during my presentation. It was open for signatures in 2001, which means basically it was completed in 2001, and therefore countries that wanted to adhere to it could do so from that moment on. But it actually only came into force in 2004, and the reason it took that long is because in order to come into force, it had to be ratified by 5 countries, 3 of which had to be European countries. Difference between signature and ratification, for those of you who are not familiar with international treaties, and that's going to be my little part on international law, and then don't worry about it, I'll get back to cybercrime. But simply to understand how conventions work, basically when you sign something is basically when you go to the store and you're talking to the salesperson and you go, yeah, that's interesting, I like that. So he says, well, are you going to buy? Let me think about it, I'll go home, I'll ask my wife. And when you come back with your wife's approval, that's ratification. So basically signing is saying I'm interested in being bound by this document. Ratification means I actually changed my laws, I actually adapted my legal framework in Canada, and now I can actually really apply that convention on Canadian soil. So that's where we are right now. Basically, 47 countries around the world have signed that convention. So our colleagues from the OPP will actually be happy to hear that now they have, because of this convention, they have 46 countries that they can directly contact and ask for information, because the convention actually says that all signing members have to cooperate in fighting cybercrime. So they actually have to exchange information according to that convention. So basically 46 other partners with Canada. And this is actually very, very recent. As I mentioned, Canada signed way back in 2001. So you figure, well, they probably ratified it in 2004. Actually, ratified it 2 weeks ago. So this convention actually was ratified on the 8th of this month. So not even 2 weeks ago, it was ratified. And what's surprising is that nobody talked about it. And this is important. This is huge. As far as cybersecurity is concerned, this is probably the most important development of the last few years, including C-13, which is a new bill that was referred to this morning, that basically modified Canadian laws so that we could adhere to the convention. And so ratified a few weeks ago, but will only come into force in November of this year. So basically, again, my colleagues, my friends from the OPP, you're going to have to wait another couple of months before you call up those 46 other countries for information should you need their help. So if I get back to trying to define what a cybercrime is, well, I basically looking through papers and online journals and news clippings, trying to establish what cybercrime is or what people usually consider cybercrime. I made a list, and obviously it's not a complete list. There are other elements, two of them being probably the most important cybercrimes. The first one being child pornography, which we spoke of this morning, and the second one being copyright infringement. Child pornography, when you actually look at the case law, is probably over 90% of cybercrimes. Copyright infringement is a little different because unlike child pornography, which is in the criminal code obviously as a crime, copyright infringement is actually in the Copyright Act. It's still a crime. There are actually criminal dispositions in the Copyright Act, which is relatively rare when you look at other types of legislation, but very rarely used. There have only been, according to case law, about 30 uses of the criminal dispositions of the Copyright Act, because let's face it, when somebody is impeding on your copyright, what you want is damages. You don't really want them to go to jail. You might want them to go to jail, but you mostly want them to pay up. And so not that many cases of cyber crimes related to copyright. So I'm not going to talk about those two topics, or I'm going to push them aside, simply because, as my title suggested and as was asked of me for this presentation, I'm really going to concentrate on cyber crimes that deal with information security. And in these two cases, it's not a question of information security, it's another type of cyber crime. But
I'm sorry, is the definition that you're using for cybercrime, is it those things that are unique to the cyberspace that cannot be performed or are not performed via any other method? You know, for example, you can say that spam could be used to slander people, or on a do not call list, or some analogs you can come up with. Are you specifically focusing on things that only can be done?
I will. This list actually I'm going to break down now because some of these elements, and you're actually a couple of seconds ahead of me. Oh, that's perfect. That means you're following. Basically, a lot of these elements we would tend to consider cyber crimes, or if you read, again, newspaper clippings, we'll talk about this as a cyber crime, but really they're not. And spam is the first example of that. People often talk about spam as being a cybercrime, but if you actually read the law, if you read Canada's recent anti-spam legislation, or if you actually read its official title, I'm going to try to do it in one breath, an act to promote the efficiency and adaptability of the Canadian economy by regulating certain activities that discourage reliance on electronic means of carrying out commercial activities, and to amend the Canadian Radio, Television and Telecommunications Commission Act, the Competition Act, the Personal Information Protection and Electronic Documents Act, and the Telecommunications Act. That's the actual title of our anti-spam legislation. Very easy to remember. So that law actually states that spamming is a violation, not an offense, and therefore it's actually not a crime. If it's not a crime, it can't be a cybercrime. Doesn't mean that it doesn't have penalties associated to it. but it's actually not a criminal offense under Canadian law. And it's actually the same logic under the European Convention or the Cybercrime Convention, where they actually mention, not in the convention itself, they don't talk about spam in the convention, but if you actually go in the explanatory report, they will say that such conduct, therefore sending spam, is actually not a criminal offense or should not be considered a criminal offense unless really it's akin to a distributed denial of service attack. So if you're sending spam will actually cause a system to crash, then maybe you can consider it a crime, but otherwise it is not. It's simply a violation. So that's one thing that we refer to as a cybercrime, which isn't. The second one, and that's probably the one that's going to surprise most of you, is theft of data. Theft of data is not a crime. I thought I would get a lot of jaws to drop on that one, but you don't seem that surprised. I'm a little disappointed, honestly. Theft of data is not a crime, and the Supreme Court actually said that in 1988 in a decision, R.V. Stewart, where somebody basically made a photocopy of a list of employees of a hotel for unionizing purposes. And he was sued, and also criminal charges were laid against him, saying, well, you stole our data. You committed theft. And the Supreme Court said, no, that's not theft. You copied the information, but the information is still there. And in order for it to be theft, you actually have to deprive the other party of the property. So by reproducing information, you're not actually stealing it. And we'll get back to that in a minute. And the best example of that is a recent case out of Saskatchewan. And it was actually confirmed by the Court of Appeals a few weeks ago. That was a case of revenge porn, what we refer to nowadays as revenge porn, but this was before C-13, so before revenge porn was a thing. Do we know what revenge porn is? Just for those of you who are not familiar, is basically my girlfriend just broke up with me. I have a picture of her in her underwear on my laptop, and I decided to share it with the world because, well, I'm kind of mad at her for breaking up with me. So that's the idea behind revenge porn, and that's exactly what happened in R.V. Maurer. Mr. Maurer decided to get a picture of Christine Lee and put that picture up online. So he hacked her computer, went to get the picture, and put that up online. And there were two accusations, both of which mention stealing personal data. So the act of robbing, of stealing, of theft of data. And the court actually said, well, the problem is, in order to prove theft of data, you have to prove, again, that it was taken from her and she didn't have access to it anymore. Whereas if you actually break into somebody's computer, take the information is still there, so you didn't deprive that person. They actually went a step further and said, he put that information online, so it can't be considered theft because she can just go online and download her old picture. So in a sense, you didn't steal anything. It's still available to her. It's still readily available to her. The only problem, it's readily available to half the country as well, which is probably what she did not enjoy. Now, again, this particular type of crime no longer would be prosecuted under theft. It would now be prosecuted under the new revenge porn dispositions of the law, and I'll get back to those in a few seconds. But what's odd about this, so basically you're saying if I steal information, but you still have that information, that's not theft. But if I steal your laptop, or if I steal your USB key, the value of what I stole will be calculated by what's actually on that laptop or on that USB key. So if I'm stealing a $10 USB key that has secrets on it that are worth millions of dollars, I stole millions of dollars. But if I go download those same documents or hack your system and go get those same documents, then I technically didn't steal anything. So this is one case where the law just didn't follow what a common logic would dictate. And this actually came out of a decision of the Court of Appeals in Quebec. And if you're actually looking at the convention now regarding theft of data, again, theft of data is not in the convention. What you understand reading the explanatory notes is that basically what we consider theft of data is actually two distinct crimes. The first one is deletion of data, so that's a criminal offense. And the second one is interception of data, another criminal offense. So basically what happened is you intercepted the data and then you deleted it. So the result is you have it, they don't, but it's actually not theft, it's deletion and interception. So conceptually, a little different than what we would commonly refer to as data theft. And that has direct implications. Again, in Maurer, the court basically said, had you not used the word theft in the accusations, and this is where the Crown prosecutor made a mistake, if you hadn't used the word theft, I probably would have convicted him. But you used the word theft, you have to prove theft, you did not, and so you can't I can't actually convict him.
How would you classify intellectual property then? Is that, I guess it boils down to what the definition of data is, but intellectual property, I would think, is protected under law.
It is, but then when you're talking about use of intellectual property, as I mentioned, it's a distinct crime. Then it would be under the Copyright Act, it's uploading or downloading or copying intellectual data that is protected by intellectual property. So it's not theft of data, it's a violation of intellectual property rights under the Copyright Act or under the Patent Act, depending on what type of intellectual property you're dealing with. Now, the next one I would take off the list is what, again, I referred to as revenge porn, which has been added recently to the criminal code. It was added in March of this year and would have been very useful in R.V. Maurer. And basically, it's what I just mentioned. You put online a naked picture of your ex. Now, that was actually a disposition that was adopted to fight cyberbullying. Because when teenagers would put pictures up online of their ex-girlfriends, the only real dispositions in the criminal code that applied were child pornography, because they were minors. But you don't really want to accuse a 14-year-old of child pornography when what he did isn't really to get people off who enjoy that type of stuff, but really the reason he did it was to cause a nuisance or bully another child, probably an ex-girlfriend or so. And so they adopted these dispositions that deal with revenge porn, and you have basically the definition here on screen, and that can lead to a criminal offense. But again, not a cybercrime related to information security. This is just a general cybercrime. So when you're talking about cybercrimes that are related to information security, well, you're thinking about these elements. So malware, phishing, spyware, hacking, et cetera, et cetera. But obviously, again, the criminal code did not use those definitions. There are actually 3 dispositions in the code that we can associate with these types of offenses. And they're the 3 that we see on screen right now. The first one is interception of communications. The second one being unauthorized use of computer, and I know we're missing an A in there, but that's actually how it's written in the criminal code. And the third one is mischief in relation to computer data, which was alluded to this morning. These same crimes are also in the convention, differently titled. You have illegal interception, illegal access, and data or system interference, but they, again, they're more or less synonyms of the 3 infractions in Canada, sorry. In the convention, there are 7 7, I can count up to 7, which is pretty good. There are actually 7 cybercrimes, according to the Cybercrime Convention. Child pornography, copyright infringement, the 3 that are on the screen, and then you have computer-related forgery or computer-related fraud. Now, as was mentioned by our colleagues from the OPP this morning, in Canada, computer-related fraud is just fraud. So you'll have unauthorized use of computer or a mischief in relation to computer data, and on top of that, you'll have fraud. So you'll have 2 different crimes. So it's not considered a cybercrime as such. It's 2 different elements. So there's no computer fraud disposition in the criminal code. So if I go down these 3 criminal offenses, first one being interception of communications, that one is mentioned in section 184 of the criminal code. I'm not going to read it. Again, I don't want to put you all to sleep right off the bat. Simply take the main elements out of it. In order to talk about or accuse somebody or convict somebody of interception of communications, you have to be able to prove 2 things. One, that person used a device to intercept the communication. So if you're just eavesdropping on somebody, that's not the right disposition to use. The second one is that there has to be a voluntary interception of a private communication. And if you actually look at the disposition in the convention, again, more or less the same thing. So if you can prove these two elements, you can prove that I use a device and you can prove that I voluntarily intercepted a private communication, well, then technically you can send me to jail or fine me depending on what the actual crime I committed was. Again, this is the wording for the European Convention. It's use of technological means, so or a device, and intentional interception without right of a non-public transmission. So we said a private one instead in Canadian law.
The device here is not necessarily a physical device. It could be electronic in the sense of software.
Exactly. A device is actually defined in the Act. It's defined very broadly, which is basically any type of a device that can be used to interfere or intercept a communication. There are actually some exceptions. For example, in the convention, they actually mentioned that a hearing aid, although technically a device, does not count. So if you have a hearing aid and you overhear somebody's conversation, you are not a criminal, thankfully. So originally, obviously, that disposition was adopted to talk about, and we mentioned it this morning, listening in on phone conversations, whether it be using phone lines or waves. It can obviously be used as well for video conferencing. And most interestingly, the Supreme Court came out 2 years ago and confirmed that it can actually be applied to text messaging. So intercepting text messaging is also intercepting communication, so it's not just oral communications, it can actually be text-based. So that's for the interception of communications. Second cybercrime, or second category of cybercrimes, if you will, is the unauthorized use of a computer. That's mentioned in section 342.1 of the Criminal Code. Just so you know, and I should have mentioned it for the interception of communications, these dispositions, probably because, and I'm going to send some very kind words to our friends from the OPP up there, probably because the cops are doing their job so well that people will actually plead guilty very quickly, have been tested in front of the courts very rarely. Interception of communications, about 30 instances in case law that mention it. And usually it's because a warrant for intercepting data has been obtained by the police and the accused considers that it wasn't the right warrant. So it's not even criminals that are being accused. It's basically we're saying the police officers did not get the right documents to have access to the data. In this case, unauthorized use of computer, if you're actually talking about the offense itself, about 39 cases, and almost all of them refer to employees breaking into their employer's system. So people who actually are not hacking the system because they have a username and password. So very few cases that actually deal with cyber criminals in the way we think, so hackers and so on. And the second paragraph actually of that same section, so 342.1 paragraph 2, actually defines what a computer is, and I'll get back to that in a second. And so there are about 100 cases that quote that paragraph, but those cases are almost all child pornography cases where the judge basically says you're not allowed to use a computer to contact a minor, and a computer is defined as it is in section 342. So that's long side note to say that basically we're not using these dispositions a lot. So one of two reasons, because again, cyber crimes are committed and we don't know about it, or because people will plead guilty before actually making it in front of a judge. So 342.1, 342.2 actually goes on to add that if you build or sell or use appliances or devices, that can allow unauthorized use of a computer, that is also a criminal offense. So unauthorized use of a computer, in this case, you have to prove that the use of the computer, so you basically got into a computer under fraudulent means, and without a color of right. So those are the two elements in this case that you have to prove in order to send somebody to jail. Under the European Convention, they actually talk about intentionality and the absence of right again. So a little different in the wording, similar, but still the differences are important in this case. Fraudulently and without color of right is a little more nebulous. And you'll actually see it in the case law where judges don't actually bother to make a separation between the two. They just say, yeah, that was done fraudulently and without color of right, but you actually don't know which of the two is the element that they focused on. Whereas intentionally and without right, well, those are very distinct categories. But at the same time, something can be done intentionally, but without any ill will or without any criminal intent. And one example of that is R.V. Parent, a Quebec decision, where basically a police officer gave information that technically he was not allowed to give, but he gave it to a private investigator who he believed was basically fighting the good fight. He was investigating to find out about criminals. So he figured, I'm sharing with somebody who has the same mission. So this was done obviously without color of right. It was obviously done intentionally, but it wasn't really fraudulent. So the court decided that he was not guilty of the accusation. A similar case, somebody from the Société d'assurance automobile du Québec, so car insurance society in Quebec, and basically an employee decided to sell information to a member of the public. The problem is the member of the public was actually a member of a small biker gang that is referred to as the Hells Angels. I don't know if you've heard about them. But back in those days in Quebec, they were not exactly the most popular people. And therefore, that was considered to be not only without color of right, but clearly fraudulent. So it really depends on what your intent is when you're accessing the information. I have a bunch of other examples that we can discuss further if we have the time. And now comes the important part. Obviously, we're talking about breaking into a computer system. Well, what is a computer system? And this comes back to the question you asked this morning about the refrigerator. Is a smart refrigerator a computer system? And the answer is probably yes. You have the definition here on screen of what a computer system is, and it's any device or a group of interconnected or related devices that contain computer programs or other computer data, and that by means of such said computer programs performs logic and control and may perform any other function. So that's a relatively broad definition of what a computer is. So it obviously applies to your desktop or your laptop, but it also applies to servers, as was the case in R.V. Platier, which is a Quebec decision. Brilliant. This gentleman was fired for I don't know exactly what reason. So he actually broke into the Department of Justice, who he worked for. He broke into their system to replace the letter of dismissal by a letter of promotion. And he thought nobody would notice. And so he showed up the next day to work, and obviously his scheme did not work, and he was still fired. And on top of that, there were criminal accusations laid against him. So breaking into somebody's server, a server is a computer. A game console is a computer. Was a case, R.V. Hamel, again in Quebec. And for some reason, all the cyber criminals are in Quebec. I don't know why, but I mean, we have in Montreal a very strong IT component, so maybe that's why. I have no idea. But all that to say, so most cases are from Quebec, and in this case, this was a guy that would pirate Xboxes. So he would modify the Xbox so it could read cloned cartridges or CDs rather. I'm old school. I still think of the Nintendo cartridges that you had to blow into. But basically now the Xbox, they're CDs, and you can burn those CDs, but the Xbox won't read it unless you actually go into it and modify the system. So he was accused of hacking the Xbox, and he was actually acquitted, not because it wasn't a computer, but because technically what he did wasn't illegal. What was illegal was the person who used it afterwards to read a copied game. An ATM, R.V. Sioketa, R.V. Ono's, Alberta cases in this case. Actually, it's the same case. It's just the two co-defendants that asked for a split trial. And they hacked into an ATM, and that is considered a cybercrime, or rather access to a computer system. A cell phone has been also considered to be a computer. So again, anything technically that has software in it could be considered a computer. So I was on driving here this morning, I was listening to the French version of the CBC, Radio-Canada, and there was actually, and I have 10 minutes left, no problem, and there was actually a journalist was talking about the cars that are the easiest to hack into. And I believe it was the Jeep Cherokee that was actually the easiest car to hack into. Well, if you can hack into it, that means it contains computer programs and it performs logic and control, and therefore that car in that circumstance would be a computer system. So you could use Section 342.1 to lay down criminal accusations against somebody who pirates the system of a car. Which leads us to our third and final cybercrime category, and that's mischief in relation to computer data. That is mentioned at Section 430 of the Copyright Act. And again, like most other dispositions, two things that you have to prove. You have to prove that the mischief was willful, and you have to prove that it was without right. Now, that's actually not specifically mentioned in the disposition. It is mentioned in the equivalent disposition in the Cybercrime Convention, where they say it has to be intentional and without right. But obviously, if it's intentional and within right, so if I erase this presentation from my laptop at the end of the presentation, I didn't commit a crime because I had the right to do so. So there again, very rarely have these dispositions been used. There are only 4 cases that quote that section of the law, 2 of which are the Maurer case I spoke of before. So first, the first decision and the appeals decision. So very rarely used. So what are we talking about when we talk about mischief in relation to computer data? Well, basically it's everything that has to do with attacking the integrity of data. So it's deleting, damaging, deteriorating, altering, or deleting data. So it's all of these elements. So if you do one of these things, you're willfully, if you do these things willfully and on somebody else's computer, for example, then you're committing mischief in relation to computer data. And the best example of that, and I as a university professor, I love this decision, Koshar v. U of Saskatchewan. So in this decision, they actually talk about the criminal case that was against Mr. Koshar. He was unsatisfied with his university grades. And so instead of studying harder and taking new classes to bring his average up, he decided to hack into the university's computer system and give himself 17 A's instead of the 17 D's I presume he had. Or it just said he changed 17 grades, so I figure he gave himself better grades. Otherwise, he's not as smart as he thinks he is. Unfortunately, he got caught and accused criminally under Section 430 of the Act as committing mischief to data. But this is one example where the criminal trial is actually not in the case law because it was settled out of court, or rather he pled guilty, I'm guessing, because there's actually no trace other than the fact that that decision was mentioned in this civil trial where Koshar was actually suing the university to let him finish his studies, and the university said, well, we don't really want you as a student here anymore for obvious reasons. So that in a nutshell and in 32 minutes is basically what cybercrime is from a legal standpoint, and that lets you understand a little better why there's so much discrepancy sometimes between what we perceive as cybercrime and what we see in the media as being prosecuted by the courts, or in front of the courts, I should say. So I thank you for your attention, and if there are questions, please.